There's been a significant development in a federal lawsuit challenging state bans on suppressor ownership, and what's happening in this case could have far-reaching implications for Second Amendment rights across the country. Two consolidated lawsuits, Morris versus Rowell and Anderson versus Rowell, are challenging Illinois' ban on suppressor ownership and possession. These cases matter because while most states allow suppressor ownership, 9 jurisdictions still prohibit them outright. If successful, these lawsuits could establish that states cannot constitutionally ban these National Firearms Act items, setting precedent that would affect suppressor laws nationwide. Unfortunately, the district court recently granted Illinois' motion to dismiss the case entirely. The court ruled that there's no historical tradition showing suppressors are protected arms under the Second Amendment. Because suppressors didn't exist at the time of the founding, the court concluded that plaintiffs failed to demonstrate these devices deserve constitutional protection. The case was thrown out completely. However, this fight is far from over because the plaintiffs have appealed to the Seventh Circuit Court of Appeals, asking the higher court to reverse the lower court's decision. This lawsuit relies heavily on the Supreme Court's landmark decision in New York State Rifle and Pistol Association versus Bruin. In that case, Justice Thomas authored an opinion that struck down New York's may-issue concealed carry licensing scheme, finding it inconsistent with the nation's history and tradition. One of the primary holdings in Bruin was that the government bears the burden of proving their gun restrictions are consistent with our nation's historical tradition. This was a significant shift in how Second Amendment cases are analyzed. The government must now justify their restrictions by demonstrating they align with historical practice, rather than simply asserting a public safety interest. Here's where the Illinois case becomes particularly troubling. The district court appeared to flip that burden entirely, requiring the plaintiffs to prove suppressors have historical protection rather than making Illinois justify its ban. This represents a fundamental misapplication of the Bruin framework. Under Bruin, once a plaintiff demonstrates that suppressors are arms used for self-defense, the burden should shift to the state to prove that banning them is consistent with historical tradition. Instead, the Illinois court placed the entire burden on the plaintiffs to show historical evidence that suppressors specifically were considered arms in the founding era. The plaintiffs made strong arguments rooted in how constitutional rights have always been understood. They argued that the Second Amendment's reference to arms isn't frozen in the 18th century. Just as the First Amendment protects modern forms of communication like the internet and social media, even though these technologies didn't exist in 1791, and just as the Fourth Amendment applies to modern forms of search like cell phone data and electronic surveillance, the Second Amendment extends to all bearable arms, including those invented after the founding. The plaintiffs emphasized that while the Second Amendment's definition of arms is fixed according to its historical understanding, that general definition covers modern instruments that facilitate armed self-defense. Suppressors, they argued, are simply modern tools that make firearms more effective and safer to use, reducing hearing damage while maintaining the firearm's defensive capability. Illinois took the opposite position, arguing that suppressors aren't protected because they didn't exist at the founding. Without a historical analog from the founding era, the state contended, these devices fall outside Second Amendment protection entirely. The district court ultimately sided with Illinois, but in doing so, created what appears to be a novel and problematic legal test. The court ruled that a modern item is only protected if you can point to a historical analog from the founding era. According to this reasoning, since suppressors are accessories rather than weapons themselves, and since no colonial-era sound suppression devices existed, there's no constitutional protection for them today. The court's analysis went even further into concerning territory. The judge wrote that the record was devoid of any reference to a time in American history where an earlier device, accessory, or attachment was broadly employed to reduce the sound of a firearm. The court stated that if there was no colonial-era or antebellum period archetype to a modern silencing device, it's difficult to understand how the framers would have understood the ordinary meaning of the word arms to include a device that reduces the report of a firearm. This reasoning essentially locks the Second Amendment into the technology available in 1791, suggesting that any advancement without a direct historical predecessor might be unprotected. Interestingly, the court acknowledged that some attachments might be protected if they're integral to the effective operation of a firearm. The judge gave examples like firearm sights, noting the technological progression from no-sighting devices to iron sights, and eventually to modern sophisticated optical sights and red dots. The court suggested these might qualify for protection because historical firearms had some form of aiming mechanism, even if primitive. But this creates an arbitrary distinction. Why would sights be protected because colonial muskets had crude aiming systems, while suppressors wouldn't be protected simply because the technology to reduce muzzle blast didn't exist yet? Both enhance the effective use of a firearm. This reasoning is deeply concerning for several reasons. It suggests that any firearm technology or accessory without a direct precursor from 1791 could be banned. Under this logic, modern ammunition, polymer frames, electronic triggers, advanced optics, and countless other innovations could all be deemed unprotected. The court seems to have misapplied Bruin fundamentally. The Supreme Court never said modern arms need historical analogs to receive protection. The historical analysis in Bruin applies to government regulations and whether those regulations are consistent with historical practice. It doesn't apply to the threshold question of whether something qualifies as an arm in the first place. The Supreme Court has long recognized that constitutional rights apply to modern technologies. In the First Amendment context, the court has protected speech on the Internet, even though the founders never contemplated such technology. In Fourth Amendment cases, the court has applied constitutional protections to cell phones and GPS tracking, despite these being inconceivable in 1791. The same principle should apply to the Second Amendment. The right to keep and bear arms necessarily includes the right to possess modern arms that serve the same basic purposes as founding-era weapons, even if the technology has advanced. The case now moves to the Seventh Circuit Court of Appeals, making it the most advanced suppressor challenge in federal court. Similar cases are pending in New York, New Jersey, and California, but this Illinois case is furthest along in the judicial process. State attorneys in those other jurisdictions will almost certainly cite this district court ruling heavily, arguing that suppressors lack historical protection. This makes the Seventh Circuit's decision critically important. The appeals court could either validate this restrictive approach, which would threaten protection for numerous modern firearm accessories and technologies, or it could reject the district court's reasoning and reaffirm that the Second Amendment protects modern arms and accessories that facilitate self-defense. The outcome of this case could significantly impact not just suppressor rights, but how courts analyze Second Amendment protection for any modern firearm technology. The fundamental question at stake is whether our constitutional rights evolve with technology or remain frozen in the 18th century. If the Seventh Circuit upholds the district court's reasoning, it could open the door to banning any number of modern firearm features and accessories simply because they lack an exact historical predecessor. Conversely, if the Seventh Circuit reverses and applies Bruin correctly, it could establish important protections for suppressors and other modern firearm technologies across multiple states. This legal battle will continue to unfold over the coming months, and gun owners nationwide should pay attention. The principles being debated extend far beyond suppressors to the broader question of how the Second Amendment applies in the modern world.